Judge Masipa dismissing the state's application for leave to appeal, saying she doesn't believe that there are reasonable prospects of success, that another court would reach a different finding. Just for some reaction on this, I'm joined by constitutional law expert Advocate Mark Oppenheimer. Mark, thank you for joining us. The hurdle for the state, how tough a climb was this, a hill to climb was this for the state in the first place?
It's particularly hard in the circumstances. In sentencing proceedings, it's the case that the trial court is best placed to determine what a just sentence is, and that an appeal court that hasn't spent time with the accused and with all the witnesses in person will not readily interfere with the decision of the original court. And on that basis, it makes it that much more difficult for another court to decide otherwise, which undermines the reasonable prospects of success that the state would have had.
Now, Null has made a lot of the fact that it doesn't send the appropriate message. Dolus eventualis, murder, 6 years. It's not an appropriate sentence, called it shockingly light and inappropriate. Do you see them on that basis pursuing this to the SCA?
Well, it's open to them to petition the SCA to appeal the finding. I think it must be borne in mind, while it seems that there is a narrow difference between the original 5-year sentence and the 6-year sentence, this 6-year sentence will be in addition to the 2 years that have already been served, those in prison and those under correctional service. Also, the parole requirements are different in the 5-year case and the 6-year case. So while it may seem that it's only a marginal increase, the real effects felt by Oscar will be much more serious than before.
How difficult will it be for the state to have this heard by the SCA? How stringent is that test?
Well, it'll be open to the SCA to decide whether or not they're willing to hear the matter, and they're going to have to apply their minds accordingly. I think it will be a hard hurdle for them to climb.
And in terms of the time frames going forward here, is it correct that the state now have 21 days within which to directly petition the SCA?
Yes.
And just in terms of the amount of public scrutiny, the amount of public interest in this case, do you believe that the National Prosecuting Authority, while the judge said that that is not going to inform her sentence, it still needs to send an appropriate message and be in the interest of society? Is Nell, while he said nothing as he walked down the stairs here, do you think they already have something, a roadmap in mind?
Well, it is also open for them to say enough is enough, that they've fought their best fight. I think there must be a distinction between what the public has an interest in, which might be to bay for blood, and what's in the interests of the public. And the test really is the latter test, whether Oscar poses a threat to the public safety. Those are the sorts of things that ought to be taken into account, not the fact that the public is dissatisfied with the sentence. The public are often not best placed to determine what the correct amount of sentence ought to be. Really, a trial court is better placed.
Advocate Mark Oppenheimer, thank you so much. So we are in all likelihood going to be heading to the Supreme Court of Appeal in Bloemfontein. The state are yet to make a call on that. Advocate Harry Nell briskly walking past us here, was asked for comments, said nothing, but I'm sure we'll perhaps learn what the state's plans are from the National Prosecuting Authority, if not today, in the coming days.